One of the organizers, I had no choice but to accept the almost impossible mission of chairing the last panel of today and trying to keep you alert. But with the help of my distinguished friends and speakers, we hope that we will be able to keep you to some extent. Sorry? You're not hearing? Okay. I'll try to come closer. So I was just saying that I'm trying to that being one of the organizers of the conference, I had to undertake the almost impossible mission of chairing the last panel and trying to keep you alert at this time of the day. And I'm hoping that with the help of my distinguished speakers, we will be able to do so. So this panel will discuss the one important aspect of class litigation, class actions, having to do with the quality of legal representation. And to this end, I'll ask the first speaker, Elad Man, to come forward and speak on NGOs and class actions. Elad is one of the founders of Man Barak Advocates, Solicitors and Notary, which mainly deals with international commercial law and litigation. But I think, to my taste at least, more importantly, he is one of the founders and the chief legal advisor of Hatzlacha, Success in English, which is a consumer movement promoting fair society and economy. They conduct actually class actions, they file class actions to court with an attempt to achieve social justice and protect better protection for consumers. Well, I have a very long list of achievements that I'm not going to go through all of them, but I want to indicate that in addition to his law degrees, Elad has a BA in political science and international relationships and an LLM in commercial law executive program of Tel Aviv University in collaboration with UC Berkeley, California. He's also a solicitor in England and a lawyer here, and he's doing now a PhD in Tel Aviv University. He's also he also contributes regularly to some of Israel's best and most important newspapers, such as Haaretz, Globes, The Marker, Calcalist, and others. So, Elad, please go ahead.
Okay. Thank you all. First, I'd like many more before me, to thank Ariel and Rabia for marvelous organization of today and probably tomorrow, if nothing will happen.
You don't know yet.
And to I can anticipate. And to thank also the other sponsors of this wonderful convention that truly showed us that this important subject of class actions is very, I would say, of much interest around the world, not only in Israel, when you see greedy lawyers chasing every possible cause in order to make a few more shekels, like we were taught this morning by Chief Justice Grunus. But they always say that the big advantage in being the last to speak is that before you spoke, everyone has already was giving examples and slides and many wonderful ideas, but the big misadvantage is that you're left with nothing to say. So I will try and be meaningful even for a short while. And what I'd like to speak today is from the point of view of an organization about the option in Israel, the local option, because we heard before about the overview mostly in Europe of organizations that can file class actions. I would like to speak about the Israeli case, which is relatively new and developing, and just to illustrate how new and developing. I think the statistics between 2006, which the new reformed class action law was introduced, and until 2012, and Asaf will correct me if I'm wrong, about 6 class actions were filed by organizations. And since 2012 and until today, I think that we're talking about 10 more, and that's it. Those are the numbers, and you've heard that we are on an annual rate of more than 1,400 class actions. So we're talking about an isolated, small group of class actions, but to my taste, a very meaningful section of the practice. So let's start by understanding what is an organization under Israeli law, and basically I gave here the complete wording from the reformed legislation. It's a corporate body which operates at least for 1 year, promoting public purposes, and is not connected to any political party or other body with political aims. Basically, there's no need to register for the purpose of being an organization that can file class actions. We'll later see that for other purposes, like dealing with settlements and regarding the ability to step in an already existing class action, you need some kind of registration and authorization by the minister. But basically, in order to file a class action, you don't have to do much, only to be an organization that is active for at least 1 year, and that the class action will be in the scope of one of the public purposes promoted by the organization. The main thing that the legislation that introduced the mechanism of organization said about the conditions is the condition regarding the need to show a difficulty in filing or conducting the class action by a person with a personal cause. And this is the big riddle that we're facing in organization litigation these days. We are, I think, after the decision that I'll speak about in a few minutes of Hatzlacha and Cohen Pituach, we have less questions, but it's still one of the issues that are very controversial between plaintiff and defendants on what is difficulty and how we can define it. So I think we should speak about difficulty. So when the first class action that we've filed in September 2012 on a security issue, we did not know how to demonstrate difficulty. We had some thoughts about what can be perceived as a difficulty, but we were walking basically in the dark. And some of those initial thoughts were were concerned with issues like inherent difficulty. What would you think is an inherent difficulty when you're coming to file an organization class action? Let's say limitation. If the cause is on the verge of being on the end of the limitation period, then one can say that there's an inherent difficulty to file. It's an indication that can bring us to the thought that until now, until the end of the period of limitation, no one filed this action. So there must be something, if the cause is right and the cause is based on a good ground, something holding back regular plaintiffs from filing this claim. So this is one of the options. Another option is an uninformed group. Let's say there are members of the group who have a right that was infringed or not enforced, and they don't know about it. Every member of this group that will come forward knowing that his right was infringed, and he'll go to the defendant and say, I want to exercise my right, he'll get paid, or he'll get what the defendant should give him. But then he cannot be lead plaintiff anymore because he does not have personal cause. So if there's a question on uninformed audience, that could be seen as a difficulty also. The other thing is conflict of interests, or let's say other problem of representation within the group, like in the case of institutional investors that are connected to the potential defendants. Mainly you see that in security class actions. So you see a market failure. It can be associated with other relationships that the potential plaintiffs with personal cause has with the defendants, and sometimes it relates to the complexity of the case presented. We mainly see that in antitrust cases, competition, and against securities. So although there's something which is very crucial for the group or the class, no one personally will take it forward, and you need someone from outside to observe and promote this kind of litigation. Okay, so those thoughts are on a more philosophical base. But then the organization takes the decision and files the class actions. And that's what we did in the Cohen Pituach case. And on early 2013, we got a decision from the court, the economic department of the Tel Aviv District Court, basically giving us a menu of what can be seen as a difficulty and how to find it. This case was a security case, and what we've done before filing the action is we wrote a very, some would say less detailed, we would say more detailed letter to several institutional investors, big investors that we knew that are holding the securities of this, this specific company. And we told them, you should be aware to the fact that there is a potential cause and you are potentially members of the group. We urge you to take this litigation and to file the class action yourself. Mysteriously, most of them did not respond, but and we had a few of them that responded, but it was an immediate impression that salvation will not come from this part of the world. So we thought this was the decision point, and we filed the action ourselves. And the court said, after reviewing what we've done, that we could have done it better, but it's a process that is demonstrating difficulty to a level which is required, and that if you can state or if you can demonstrate that you've reached out for a reasonable amount of potential class members, and you've given specific, adequate details on the possible cause, and no one took the opportunity of filing the action, then the demand or the point regarding difficulty is satisfied, and you can be an organization can be the lead plaintiff. And then some other questions has come up, like the question, what is the right time to demonstrate the difficulty? And should we check it on the day of filing the class action, or are we talking about something which continues into the litigation? And because life is interesting and complex, after we filed the class action and got this decision, the first decision on the motion to dismiss, that did not dismiss the action, two people with personal cause approached us and said, actually more than two people, but and said, we are willing to join the litigation. Then the obvious thing that defendant said, it's expected them to say that you are not needed anymore. We have people with personal cause. They can lead the litigation. They can be lead plaintiff. You should move aside and withdraw from the litigation. And the court said that the right slot of time to examine the existence of a difficulty was at the time of filing the class actions and not later. Because after you have a court decision stating that the claim is on, I would not say a solid ground, but it had some merits, and the ISA gave financial support to the litigation, then any reasonable potential plaintiff with a personal cause would say, this is a good case. I want to take this case. But someone already made the hard work before. So it would be negative incentive for organizations to try and bring in the future such cases which are problematic on initiation to begin with. So the court said we don't want to do that. Okay, so the right point of time is a day of filing the class action. Second, there was a dilemma: what is the right stage for judicial review for the participation of the organization? And the difficulty is the motion to dismiss the right occasion to discuss such questions, or should we proceed with hearing the motion to certify the class action, and only after hearing evidence on that and looking on the circumstances connected with the specific cause, understanding more about the possible difficulties of a personal cause plaintiff stepping forward, then we can have the right impression of is there a difficulty, or is the organization is the right entity to lead this claim. And I think this decision reflects an holistic approach to the process of certifying motions, because I think for the first time after a long set of controversies over that, it began to be clear that the most important thing is the cause and not the plaintiff. And this is also important in light of what Section 8 of the legislation is saying, that you can replace a plaintiff if he's not adequate, if he's not the right plaintiff to take this litigation forward. So the focus, which was before set for the discussion of who is the right plaintiff, and he brought the cause with him, now the cause is the queen of the discussion, and the plaintiff is less important. Okay, and that brings me to remarks we made when legislation was formed. One of the early discussions was, why do we need personal cause anyway? What is the purpose of insisting on plaintiff with a personal cause as the main road to litigate class actions? To my opinion, I don't think it's necessary. I heard Chief Justice Grunis today stating it was on the hallway, but I think I can repeat what he said, and no non-disclosure agreements were signed. So I think this is the direction we're going to. So personal cause is out of the discussion, and the discussion of the cause itself is the right discussion. Another interesting thing that came up in another case we are still litigating is the issue of standing. What happens with causes that are formulated or created before the organization was formed? Can the organization lead class action on something that came to the world before it was created? And on that, in the case of Hatzlacha and Elal, Judge Grosskopf said that because we're talking about procedural mechanisms, the fact that the organization was not formed at the time of creating the cause does not prevent the option of the organization being the right or the appropriate lead plaintiff and giving him the opportunity to lead the litigation. By the way, on the same case, one of the things that defendants said that they do not understand why we've waited for so long. This was a case that was on the verge of the limitation period, almost 7 years, and the simple answer was that we were not formed 7 years before, so we couldn't have waited 7 years for that. So that's like holding the rope from its two sides. And so now I want to say a few words about the roles of organizations in Israeli class action litigation. The first one is obvious, filing the actions when no one else can do that, or when the organization is the right entity to pursue the action. But the legislator had given two more roles or functions to organization, and that joining an already existing procedure in order to present an opinion or to be a part of the litigation. I'm not aware of many cases, many litigations that were joined by organization, and that's because there are not many organizations that are authorized to pursue the power the legislator has given them under this section, because Section 15 and Section 18 requires an authorization by the Justice Minister, and only a few organizations got this authorization until today, since 2006. The last part is locating plaintiff with personal cause in order to initiate class actions which are worthy. Okay, and Advocate Shavit mentioned the Verifone case and the second opportunity to hear the case, and actually after the first litigation was over, the case was presented to Hatzlacha in order to examine the possibility of Hatzlacha taking the case as lead plaintiff. But you need to go through the first stages of what Judge Kabub said in his decision in Cohen Pituach in order to locate or try to locate plaintiff with a personal cause. And I'm happy to say that we were successful in that. So a plaintiff with a proper plaintiff with a personal cause came forward after we reached out, and he's the lead plaintiff on the second litigation of the case of Verifone, and we'll see how that ends. But this is also an important role of organization because of ethical issues of solicitation. We now we're waiting for a decision of the Supreme Court. 7 judges are going to decide on the scope of entrepreneurship that lawyers can take on initiating a class action. Actually, Hatzlacha presented an amicus on this case, and you can imagine that we think the answer should be very liberal answer and regime of allowing the entrepreneurship of lawyers on the proper cases, on the right, in the right way to do it, to go forward, and to leave questions of personal cause and initiation aside, because they are less important. And I'll finish with happy news that we got today. This is the certification of Hatzlacha that we got from the Ministry of Justice today, certifying us as an organization for the purpose of sections 15 and 18. So, and to the best of my knowledge, no organization dealing with economic regulation and securities, antitrust, competition, and this kind of litigation was never certified before. So I think we can expect now that the opportunities of a more interesting litigation by organization on those areas should be developed and grow after we got this certification. I'm not saying that we're going to chase every case in the neighborhood, and just to give proportion, since 2012 that we filed the first class action, and until today we filed only 5 class actions. So there's nothing to fear of, and organizations are still a small part of litigation, but I think it's a very important growing field and should be nurtured also by the courts, because organization bears with them a lot of advantages for the procedure itself, and as returning players, they also accumulate the right experience and expertise in the fields that they are dealing with. Also, they are expected to follow not only the cases that give back more money, or that you can win a better share of fees and compensation for the plaintiff, but organizations should go and litigate the cases that no one else would like to litigate, not only on compensation, but also on other orders which are important, and cases which are more complex on the economical side, and has much more uncertainty with them, but should be brought into court for specific scrutiny of the court. So the organization should not replace the plaintiffs with personal cause, but come into action when the lawyers and the personal cause holders cannot perform correctly. Thank you.
Thank you very much, Elad, for this really very informative lecture. I'd like to invite Dr. Ariel Fulvian to speak to us about the appointment and replacement of lawyers in class actions. It's really a pleasure to introduce Ariel, who is a very dear friend of the law faculty. He teaches class actions at the University of Haifa. He's also a solicitor in England and a senior partner in Herzog Fox Neiman, one of Israel's actually biggest law firms. Ariel obtained his PhD from Brunel University in London, and he wrote he wrote his thesis on European collective redress and lessons from Israel, and his PhD is available online, was published online by Brunel University. Ariel also published a number of articles on class actions and a book chapter recently published by the Institution of International and Comparative Law. The name of the book is Collective Redress in Europe, Why and How. Ariel, please.
Thank you, my friend Rabia. I know it's late. We had a hard day, and I'm trying to sail at this late hour in a US idea for you. At least it is sold free of charge. From time to time during the presentation, I will refer to some articles. They are all listed in my abstract, which is published online. Okay, as our friend Elad just provided, NGOs' involvement in class action is very welcomed. Actually, in England, Professor Mulheron called organization involvement as ideological claimant. It is the main actions in some European states. France, Italy. Unfortunately, in Israel, there are about less than 1% of the actions are being brought by organizations. Public authorities are also allowed to bring actions in Israel. As we heard today from Alon, no action was filed by public authorities thus far in Israel. We have very active business with private individual actions, and all of them are listed in our registry. The class actions in Israel are based on private lawyers and private litigation. Lawyers may act as private attorney generals, as you can see the articles by Bill Rubenstein I referred to. Private enforcement by lawyers may further public goals, as Mary Giles wrote in her article, which I heard somebody earlier referring to this article. It may save public funds, no need for public involvement. The interpretorial work of a lawyer entails different skills from litigating lawyers. It entails research, time-consuming finance that may be spent, and a lot of evidence search. The litigating role of a lawyer is totally different. It's how to convince the court that you are right. The Supreme Court recently in Israel, by a split decision, decided to uphold the lawyer's role as entrepreneur. This was in the case called Barzilai versus Premier. In this case, a lawyer searched for, it was alleged that he searched for somebody that have eaten from non-kosher, non-exactly kosher food for ketchup and paste, tomato paste for the Jewish Passover holiday. The district court found that searching for a plaintiff was not acting in good faith, but the majority of our Supreme Court found that a lawyer may act as an entrepreneur. The minority opinion of Judge Rubinstein was that a lawyer should wait for his client and should not search for him. The problem of private enforcement is that things may go wrong. There is no real supervision on the lawyer. Class members are apathic to their rights. The amounts in stakes are very low. The lawyer has advantage because there's information asymmetry. The lawyer knows what the judge, for example, said, what are the views in the case, and he may manipulate this information on his behalf. As we heard in our first lectures, lawyers may be greedy. Lawyers may be greedy and abandon class interest in order to advance their personal interest. As Arthur Miller wrote, he even called it Frankenstein monsters. Action may be submitted for ulterior motives and even for blackmail, as Alon Clement wrote in 2002 in an article called Who Should Guard the Guardian? In this article, Professor Clement advocated for a private system of monitoring lawyers. Court supervision on class action should be increased. The court has a different role when we are looking at class action. One of the roles of the court is to ensure adequate representation. And if there is inadequate representation, it may undermine the binding effect of a judgment. You should remember that class members did not select the lawyer in opt-out cases and cannot supervise the lawyer's conduct. Therefore, the court must have the power to monitor lawyers' behavior and remove class lawyers in appropriate circumstances. It was also decided in Israel in a case called Eshel Or that the representative plaintiff cannot fire the class lawyer. So therefore, the only one who may regulate the conduct of a lawyer in court is actually the court itself. The power to replace the lawyer serves two goals, as Professor Clement wrote in his article on guidelines to the class action law in 2006. One, the first role is to ensure that meritorious claims will not be struck down due to lawyer conduct. The other one is to save time spent on personal attacks. This is written in regards to the representative plaintiff, and it applies, to my mind, also to the representative, to the class lawyer. When should the court order replacement? We have few provisions in the Israeli law that provide that the court may replace the lawyer in those circumstances. For example, under Section 60D, if the lawyer asks for voluntary dismissal before certification, then the court may decide to replace, but after the certification, the court must act for the new appointment. In addition, if there is problematic conduct of a lawyer or unprofessional conduct which endangers the class interest, the court may deny the action, or it can replace the class lawyer under Section 8 of the Israeli law. Conflict of interest with which following the court decides, conflict of interest between the class members may lead to division of the class under Section 10 of the Israeli law, and then in those new classes, the court should appoint a new lawyer for the subclasses. Or even when there are few, this is under Section 10 of the Israeli law. Or even when there are few actions for the same class or for the same cause of action in the same court, under Section 7, the court may decide which one of them should be, and it shouldn't be the first to file principle. The court may decide even to proceed with a second case and even to replace the lawyer of those leading actions. Thus far in Israel, the court was reluctant to replace the lawyer. Judge Inbar in Pastanona versus Levy provided that only in rare and exceptional cases where the lawyer asks for voluntary dismissal and the dismissal causes severe and immediate damage to the public interest or to the interest of the class members, only in those circumstances the court should ask for replacement. The reasons the judge Inbar provided are that it is difficult to assess the merits of the case in the early stages of the case. The search for lawyers is not the usual role of the court and may harm the neutrality of the court. It may waste judicial time, and the dismissal of the case does not bar others from bringing the same class action. I think there's also general reluctance to harm the lawyer who initiated the action, and that is another reason why the court is reluctant to appoint a new lawyer. Well, if that's the case and the court in the end of the day decides to replace the lawyer or to appoint a new one, there is no criteria under the Israeli law who should be elected. The law just provides that a notice should be published, but it doesn't cater the situation where few lawyers ask for the same job. In the US, Section 23G provides some consideration which the court must take into account, such as the work that's done before the action, experience, knowledge, and other which the court, and there are also other circumstances where the court may take into account. Like, for example, the court may ask lawyer questions and ask for information and then decide which lawyer, who is a suitable lawyer to lead this class. There are also there are few systems to appoint lawyers in the US. If there are few submissions, lawyer may divide the work between themselves in a way which is called private ordering. What happens in this system that the lawyer get an arrangement between themselves, and it always benefiting the lawyer, not always benefiting the class. A different system to appoint lawyer is under the PSLRA, where the representative plaintiff is being chosen by the court, and this plaintiff who has the largest interest in the action appoints his lawyer. But in numerous cases, following the case called Oracle, the courts in the US decided to conduct an auction. There is indeed some criticism to these auction proceedings. For example, that it's not easy to compare the fee offers that lawyers submitted. But a study showed that the action may reduce lawyer fees. This study was conducted by Laurel Hopper. Auctions in the US opened the way to many lawyers, even from smaller and younger law firms. It changed the rationale in class actions that courts decide lawyer fees only in the end of the legal proceeding, and therefore it adds certainty to the class lawyer, because from the outset he knows what will be the outcome in relation to fees. Now, how would I suggest to conduct an auction? The first stage would be to look at the quality of the legal representation. That may be a requirement of some experience on work, similar work being done by the same lawyer. The second stage would require a simple competition on the offered fee to enable easy comparison. In addition, fee should be secured to the lawyer who brought the action in order to reward this lawyer for his initiative and for the work done until replacement. So if you replace the lawyer, it doesn't mean that the interpretorial lawyer would lose his share of the proceeds when the case will be over. Since the usual practice of class action to decide the lawyer fees at the end of the case is not applicable to auctions, the court may maintain the power to award a bonus to the litigation lawyer, and this bonus may be decided according to Section 22 guidelines on fees, and this bonus is aimed to compensate the lawyer for extra efforts invested in the case, or even sometimes to lower fees when it seems that the fee was not justified in this matter. It would be also better if the court registrar would conduct the auction in order not to harm the court's neutrality. I think that in addition, it would be correct if part of the lawyer fees will be retained and released subject to the realization of the action. This is only an idea, but it may be that one time it will be relevant to Israeli decisions. Thank you very much.
Thank you very much, Ariel. The next speaker is Professor Morris Ratner. Morris obtained his BA from Stanford University and his JD from Harvard Law School, where he also taught for some time before joining UC Hastings faculty in 2012. Before that, previously, Professor Ratner, Morris, was a senior partner in a San Francisco-based plaintiff firm. He filed a number of high-profile actions, including Holocaust-era slave labor, looted assets, dormant bank account, and unpaid insurance claims against European companies, producing global settlements worth more than 7.5 billion US dollars. Morris will be talking to you about the quality of legal representation in US class actions, focusing on the problem of conflict. Morris, please.
Great, thank you. Great, thank you very much. It's been a wonderful conference. I've learned a lot, and I'm grateful to the organizers, especially Rabia and Ariel. I'm glad to have been asked here, and I'm grateful that it's been such a fun and informative conference so far. I'm looking forward to tomorrow as well. The concern with the quality of legal representation finds expression in United States class action law in the requirement of adequate representation, and that has two components. The first part is a requirement that counsel be competent, and the second part is a requirement that the class representative and class counsel not have improper conflicts. And my talk is focused on that second component of adequacy, which is the problem of conflicts, and in particular in the context of mass torts for reasons I'll explain momentarily. I'm going to focus on 4 issues. Number 1, I'll define the problem of conflicts in take a relatively strong read. I would put in that category, for example, people like Professor Coffey, at least in his scholarship, who deal with agency costs as a loss experienced by class members. And in the right-hand column, those scholars who favor a relatively weak read of Amchem and Ortiz of the requirement of subclassing with separate counsel tend to focus on other things besides the interests of class members. For example, the interests of the system in efficiently adjudicating cases, or the interest of society in deterrence rather than in compensation. Miriam Gillies, who's been cited a few times at this conference, I would put in that camp. So that takes us to BP. The BP oil spill litigation is, in my opinion, an example of the triumph of the weak read of Amchem and Ortiz. In that case, that was the largest environmental disaster in United States history. British Petroleum was operating an oil rig in the Gulf of Mexico. It created a huge oil spill and caused a variety of different types of losses, including economic losses for those people whose livelihoods were impacted by the spill, property damage for property owners in areas around the contaminated zone, and personal injury losses, especially by cleanup workers who were exposed to oil or oil dispersants during the cleanup effort. And that case followed a typical mass tort litigation trajectory in the United States. We've focused primarily in this conference so far on class actions, but actually there are multiple overlapping forms of collective action that exist in the United States, and the two most important of which are class actions and MDL transfer and coordination. So in the modern class action statutes from the modern class action rule is from 1966. The MDL statute is from 1968. And in that statute, Congress created a traffic cop for the federal system, the Judicial Panel on Multi-District Litigation. That entity has the power to transfer and coordinate all related cases in the federal system to a single trial court judge. In this particular case, the BP case, that was Judge Barbier, who appointed 19 lawyers from 19 different firms to represent the interests of all coordinated cases for pretrial purposes. That happened almost immediately once the transfer order went into effect. And then within 2 years, that very large piece of litigation settled on a class basis, with class action certification taking place for settlement purposes at the back end, with two separate classes. One, a economic loss and property damage settlement agreement and settlement class, and the other, a personal injury settlement agreement and settlement class. Interestingly, Judge Barbier appointed the exact same 19 lawyers who were appointed at the front end for pretrial purposes to be lead counsel in the MDL proceeding, to be settlement class counsel in both the economic loss and the medical benefits class action settlements, and did so even though there were arguably tensions between the members of the two different settlement classes, and certainly within those settlement classes among settlement class members. So, for example, in the medical benefits settlement class, one's share of the settlement depended on whether one was a cleanup worker or a property owner. If a property owner, whether one was in Zone A or Zone B, zones that were negotiated by counsel with BP, negotiations that resulted in trade-offs, essentially, structured into the settlement matrix itself, into the claims program itself. And that matrix included as well both persons who were presently injured and exposure-only plaintiffs. As to the persons who were presently injured, there were differences among them based on type of injury, and when negotiating the matrix that was the heart of the settlement, the payout matrix, class counsel made trade-offs among settlement class members depending on type of injury as well. And similarly, in the economic loss settlement, one's the extent to which one benefited under the settlement depended on a variety of factors that pitted settlement class members arguably against each other to the extent trade-offs were made in structuring the economic loss settlement. So geographic proximity to the spill, the type of business one had, the type of injury one suffered, all affected both the proof one had to submit in support of a claim, for example, whether one had to prove causation or not, and the scope of the benefits available to a class member under the settlement. So to underscore the fact that trade-offs were made when among class members in this undifferentiated class, all represented by the same 19 lawyers, when the settlement was structured in both the medical benefit settlement and the economic loss settlement, I just point to this one quote from the trial court when approving the economic loss and property damage settlement that acknowledges that some class members would have done better under the voluntary scheme that BP constructed to comply with its obligations under the Oil Pollution Act, what was called the Gulf Coast Claims Facility that was run by Ken Feinberg. They did better under that prior entity than they did under the settlement agreements because different trade-offs were made at different moments in time. The GCCF represented one way of balancing the interests of different groups of class members, and the settlement agreements represented another one. And while the judge found that didn't have any bearing on the adequacy of the settlements, it does have bearing on the point I'm making, which is that there was a particularly weak read made here of the Amkim and Ortiz decisions and of the need for subclassing. A number of high-profile, well-respected scholars were hired by the settling parties, either plaintiffs' counsel or BP, and submitted affidavits in support of the settlements, including in support of the adequacy of representation. Arthur Miller, Robert Klonoff, and Jack Coffey all submitted affidavits supporting the settlement. Jack Coffey's arguments were fairly typical of those made, and I just wanted to briefly address them. He made arguments of two types to distinguish the BP case from Amkim and Ortiz. First, he said, well, the BP settlement funds are uncapped in that they'll pay all qualifying claims. The problem with that argument is it fails to recognize the trade-offs that are structured into the settlement itself. The settlement was basically a series of matrices, one for personal injury claims, one for economic loss claims. And so while it's true that BP was obligated to pay all qualifying claims, what a qualifying claim was and the amount that it owed involved negotiated trade-offs at the front end by the plaintiffs' lawyers and BP when negotiating the settlements. Points 2 through 5 are all basically points that go to the opportunity to have additional alternative structural assurances of fairness besides subclassing with separate counsel. And that is perfectly consistent with the weak read of Amkim and Ortiz, but it directly contradicts the argument made by the Second Circuit Court of Appeal in the Literary Works case that these are not good substitutes for having lawyers whose fees depend on the success of their subclass clients negotiate these kinds of allocation trade-offs for subclass members. So my question that I posed in the extended abstract was, how did we get here? How did we get from the strong read of Amkim that the Second Circuit represents to BP, which I think is representative of the majority view of most of the circuit courts and certainly most of the trial courts in the federal system? And I have three answers to that question. One is in regards to the limited role that the Due Process Clause plays in United States procedure. The second is in regards to the structure of mass tort litigation in the United States. And the third is in regards to a systemic bias in favor of settlement in the United States. The doctrinal explanation of how we got from Amkim to the BP settlement is that Amkim tethered its inquiry into adequacy, into conflicts, to the Due Process Clause. But the Due Process Clause doesn't ask what's the optimal level of competition among counsel, or how can we do our best to tether class counsel's interests to the interests of class members. It asks a different question, which is what level of conflict rises to the level of a Due Process Clause violation? That is, what types of conflicts are so outrageous that we would render them constitutionally defective? And by asking that question, the court set us up in Amchem and Ortiz to have a potentially limited set of conflicts that would be deemed to require subclassing with separate counsel. The structural explanation is one of timing. As was noted by some of the prior speakers, in the United States, class action practice has largely been federalized. And in the federal system, in geographically dispersed mass torts, these class actions are first transferred and coordinated before a single trial court judge under not the class action rule, but this separate statute, the MDL statute, 28 U.S.C. section 1407. And leadership counsel are appointed at the front end of those proceedings without the courts having the need doctrinally at that moment to worry about conflicts. There's none of the concerns that arise in class actions with regard to adequacy matter with regards to, certainly around conflicts, with regards to the appointment of lead counsel in administratively aggregated proceedings, in MDL proceedings. And so by having class actions in mass torts, largely federalized, with counsel appointed at the front end without regard to conflicts, by the time class action issues arise, usually at the time of settlement, these lawyers have already litigated the case through pretrial proceedings, have already negotiated the settlement that gives rise to the need for settlement class certification, and at that moment, it is extremely inconvenient for the trial court judge to suddenly decide it's time to subclass the class and divide counsel into separate groups that would compete with each other over the terms of the settlement and settlement allocation. And so as a result, you find this systemic pressure towards the weak read of Amchem and Ortiz. And if we marry that with my last point, a systemic bias in favor of settlement, you see that there's little chance in the U.S. system for a strong read of Amchem and Ortiz to prevail. Federal courts quite openly acknowledge the systemic bias in favor of settlement in the U.S. system. So I have some additional slides, but it's been a long day. So I'll just note that if there's interest in the Q&A, I do think that for proponents in the U.S. system of a relatively stronger read, a stronger approach to managing conflicts in class actions, there are alternatives to relying on the due process clause as a vehicle for animating more aggressive division of classes into subclasses with separate counsel. But to the extent we're relying on Amchem and Ortiz, which are grounded in the due process clause, I think BP is actually the wave of the future, right? It's going to be an increasingly weak read in the U.S. federal system of the requirement for subclassing with separate counsel. Thank you very much.
Thank you. Thank you very much, Morris, for this really illuminating lecture. Any questions? Yes, Edna, please.
I would like to ask, what is the attitude towards a plaintiff who happens to be a class action lawyer, and what is the attitude? Is it a conflict or is it a possibility that he will represent himself?
I think on the Israeli case law, it's now a clear question that it's not recommended that plaintiffs should be lead counsel also, for many reasons of potential problems that can be created within the conflict of interest, some biases, expertise, and so on. So the cases that were litigated on that did not, the court did not find this situation to be the right situation, and separation should be there.
So it was discussed?
Yes.
Shillon versus Sprint Motor.
Okay. In the United States?
It would be a conflict for the lawyer for the class to also be the class representative, the reason being that there would be no one monitoring the lawyer who's primarily deemed to be focused on his fee. However, if there's a separate lawyer and the class rep just happens to be a class action lawyer, that would not in and of itself be a problem.
I should only mention that there is an article in the U.S. saying, written by Jane Burns, who claims that there is no need to have a plaintiff. The lawyer can be the plaintiff himself because the representative plaintiff is only fictitious in class actions. That opinion was not accepted by the Israeli committee once the enactment was enacted in 2006.
What's the name of the
I think the name was
article?
Shiloh versus Sprint Motors.
No, the article.
Gene Barnes.
Okay, any further questions? Remarks, comments? Okay, thank you very much, everyone. Thank you very much. It was really a very wonderful day. Just a reminder of tomorrow. Tomorrow we will